Hello, family. Welcome to another pre-recorded video for you guys. Again, for those of you that don't know, I'm Naturally Tora of Tora Talks, and I'm doing a lot of pre-recorded videos because my subscribers are not up yet. So to me, it makes more sense to go live when my subscribers are up, and then also just pick a day that's going to be, good to fit in because I have a lot of my own content creators on here in Black media that I like to listen to throughout the week. So I'm getting it together, but I wanted to bring to you guys just some information in regards to living trust and estate planning. A lot of people think that you have to be rich to have a trust. So I'm just going to go over some different types of trust, and then you guys could look into which one fits into your particular situation. So we're going to be talking about living trust, and I'm going to be reading some different trust and examples and the reason why certain people get certain type of trust. And then I'm also going to explain the differences between a will and a living trust. So that's what we're going to be talking about. And this here, I'm just going to be going over some, just some little PowerPoints that I pulled up to try to answer some questions, being that I'm not live, that some people may have. So there's a 5-year rule. It stipulates that the beneficiary must take out the remaining balance over the 5-year period following the owner's death, if the owner died after age 72. So say when they passed away, which I'm going to get into that, I don't want to jump too far ahead, but say the owner dies and now it's time to start paying out the trust, or maybe the trust has paid out maybe 3 years prior to, and there's a balance in there. That balance has to be paid out to that beneficiary over the next 5 years. So that's just something that's put in place in regards to trust. As they say here, it's called the staggered distribution trust. This is one of the most used trust of people, because as you see, the staggered distribution trust, the most widely used provisions distribute 1/3 at age 25, one half of the balance at age 30, and the balance at age 35. Because like I said, it has to be paid out over a 5-year period after, you start paying out of the trust. So a lot of people like to get this for children, especially even if they don't think the child is irresponsible, they may want to ensure that they don't blow through their inheritance, so they will have the trust distributed like this. And this is something you can speak to your banker or a trust company about how you want the trust to be distributed. But this is the trust that's used most. So it says, let's see, okay, of doing this is that the beneficiary has 3 chances to make mistakes. So my son, when my late husband passed away, he received the 6 figures from his dad with no provision in place he wasn't even 17 yet. So you could imagine. So this is something like that. You would want to put it in place like that. 25 years old, I think you're responsible by that age to handle a semi lump sum or, payouts of a trust. So, but this is how it's going to be paid out if you set up a trust. They'll explain to you why, because that's the provisions set up for this type of trust. And like I said, after you pass away, the owner, then it has to be paid over a 5 year time frame because that's how this trust is set up. So, okay, so this is something that people ask about all the time. Um, Do beneficiaries pay taxes on trust distributions? Beneficiaries of a trust typically pay taxes on the distributions they receive from the trust income, rather than the trust itself paying the tax. However, such beneficiaries aren't subject to taxes on distributions from the trust. Principal, the original sum of the money put into the trust. So just like a life insurance, you would be responsible for the interest, but not the principal, the original amount that was put into the trust account. Okay, so it's just telling you that a trust is one set up to manage property for a beneficiary if the beneficiary is a bad manager. Um, a bad money manager. The trust keeps him on a strict budget and keeps the assets away from his creditors. It doesn't keep away from the IRS, though. Courts have ruled that if the beneficiary doesn't pay his taxes, the IRS can go after the trust. The same rules apply for beneficiaries of rather regular living wills. So that's something to think about. I've seen plenty of people lose inheritance because of their bad decisions. I've seen a guy lose his whole inheritance um, due to child support and all types of things. IRS will come after those trusts. So it says after the grantor of the irrevocable trust dies. Now, the grantor is the person that creates the trust, and the beneficiaries are the persons identified in the trust to receive the assets. So, the grantor in this case will be you. The trust continues to exist until the successor truster distributes all the assets. So, the successor is a trustee. That's the person that's responsible for settling the trust after the grantor, you, pass away, or if you ever become incapacitated or unable to make decisions on your own, then you can make your adult child a trustee, family members, trusted friends. Um, but you also, which a lot of people like to do, you can make a successor, your banker. You know, they have a specific department just for trust accounts with your bank, or you can just go do a trust company itself. So I just wanted, before I start reading some articles, I just wanted to go over just a scenario that happens. I want to say it happened maybe 2 years ago, and it kind of broke my heart. There was three daughters, and the two oldest daughters, they were old enough, they were of age, and I'm going to go over putting minor children as beneficiaries on your policies and why that's not a good idea. And that's why you set up trust funds for your minor children. I'm going to tell you why. So there were three daughters. Two were older enough, they were 18 and older, and the youngest daughter, she was pretty young when the grandmother, which was the grantor that set up this it was actually life insurance, but she set up for each one of the daughters to get a certain amount, and she made each one of them beneficiaries. But uh the youngest child, she was too young to receive. So when people do that and you make minor children your beneficiaries, what happens is they're under the age of 18, so they can't collect this money in the event something happens to you before they're 18. So whoever their guardian is at the time have the right to ownership to the kids' assets. So what happened with the youngest daughter, once she turned 18, she called. I got a call for her. She was so excited. She's about to go to college and she's looking for her inheritance from her grandmother. It's gone. It's gone because mom was the guardian of that baby and mom had all rights to it. So guess what? That baby waited all this time. She gets older, she's looking for her money, the money is gone. When people put minor children on as their beneficiaries, this is what you're standing to go through, leaving your child with nothing. Because a lot of people say, "Well, I used it to take care of the child." If something happened to you, and whoever the guardian is, family, friends, they have every rights to that child's assets as their guardian. Which means that's it. That child get older. That's it. It's not it's nothing that could be done about that. So that's why it's definitely not good to make minor children the beneficiaries, and why it's best to set up trust funds for them. That way you can delegate when you want those funds to be issued to that child. Because once they're 18, whoever their guardian is not, they won't have any rights to that child's assets. So I want to go over a couple of trusts, and I'm going to go more into it once I go into these articles. But there's there's a trust, and it's a charitable trust. I'm not going to say not many people use this. It's a trust that has a charity or a nonprofit organization named as the beneficiary. So a lot of times I see people that get these trusts, people that have a estranged family that they don't speak to, or they have no family, or their family have passed away. And I see often a lot of people that have ungrateful children, and they rather leave it to a charity than leave it to their kid. They rather a charity get it than they die and their kids fight to get it. So those are most common under those type of situations. So now there's a testamentary trust, and that is when you use your will, and I'm gonna go over the difference between a will and a trust. But that's when you use your will to create an irrevocable trust. Now, the irrevocable trust, it refers to a trust where the grantor, which is you, cannot change or end that trust once it's created. So people typically pick this trust to minimize estate taxes sometimes when they're trying to become eligible for government programs. Because if you have elderly parents or grandparents, if you've dealt with this before, a lot of times if they're entering into assisted living or some type of nursing home, they want them to get rid of all of their assets to be able to be approved for certain government programs. And a lot of the older people, they've had their policies for a long time and their assets and things like that, and they don't want to get rid of those things. So a lot of times they would do something like this. It's a testamentary trust where they could still be eligible for government programs, and also it will protect their assets from their creditors. Now, there's another trust, and I'm going to go over some other ones. There's another trust, and it's called a special needs trust. It's a legal arrangement that lets a physically, mentally, or disabled person have access to the funds without losing their government subsidies. Because again, whenever you're on any type of government subsidies or you're asking for anything from the government, they basically want you to be below poverty. But if they see any assets, then you're definitely going to be ineligible. So a lot of times, parents of someone that is disabled or is getting government subsidies, they will do a special needs trust. That way, the child will still have your inheritance and plus still be eligible for certain government programs. So the difference is between a will and a trust. So a will, it goes into effect once you die. A trust goes into effect as soon as you create one. So you don't have to die to have a trust for someone and have that trust to start to pay at a certain time. A will is a document that determines how your assets should be divided upon your death. And a trust goes further by controlling how the assets are distributed. A trust requires a trustee administer. In many cases, a trust can protect the owner from creditors or legal disputes. That's the difference between a will and a trust. A will is just going to lay it out or where and who should get what. But a trust is going to go as far as protecting said assets from legal disputes, creditors, and it's going to continuously administer those funds until it's time to pay out. So that's the difference between a will and a trust. That way you can determine what's best for you, and at least you have a little bit of information. So when you go to your financial advisor, your banker, or a trust company, you'll have at least a little knowledge, of what to ask. So give me a moment. I'm going to share some things I want to go over so you'll know what things you can put into a trust for family members or children. So this is not going to be a long broadcast, but some people don't know the difference between a will and a trust. Some people think you have to be rich to set up a trust, which you do not. So I'm going to show you some of the things that you can put into a trust. So give me a moment. Thank you. Oh, okay. So let's go over. I'm not going to read all of it, but there's several types of different trusts, and maybe the ones that I read may be something that fits into your particular situation. But it says the types of assets you may transfer to a trust includes real property, including homes, land, or investment, real estate, deposit accounts held at banks and credit unions, investments including stock, bonds, and money market accounts, life insurance policies, business interests and assets, collectibles, and antiques. Funding a trust occurs when you transfer assets into the trust and under the control of a trustee. So let me go over this so you'll know the difference when you hear this, because if you're not in insurance or anything about this just doesn't, it's not going to make any sense. So when you talk about a revocable and an irrevocable trust, so the revocable trust, as referred to as revocable living trust, it allows you to maintain control of your assets during your lifetime. You can change or dissolve a revocable trust if necessary. This is why they are revocable trusts. You can revoke them. For example, if you go through a divorce or acquire new assets, you may need to update terms of the trust to reflect the consequences of those events. A lot of people want to be in control, and that's when, like I said, different situations are different. There's a lot of cases where people need that irrevocable trust, and I'll explain to you again the difference. But something like this, This allows people, just like having a life insurance policy, to be able to change your beneficiary at will. Somebody not acting right, or maybe they passed away, you can go ahead and make those changes. Like this, you have full control over whether you want your assets tied up in a trust, and it's irrevocable, and you're not even married to this person, or maybe the person has, whatever the case may be or the situation may be, you want to be able to have control over who's to get your assets, just in case you change your mind, which people do all the time. So, excuse me, it says that a revocable trust offers flexibility since the transfer of assets and the guidelines you specify for the handling of those assets doesn't become permanent until you pass away. With revocable trust, you have the option to name yourself the trustee or a co-trustee and choose someone to act as successor trustee when you die, or if you are otherwise unable to manage the trustee. So, kind of like with a life insurance, you'll have a primary beneficiary and, maybe several contingents in the case of something happens to the primary. So it says revocable trusts aren't subject to probate. That means the assets in the trust go to the beneficiaries without having to go through the probate court, which is important because some people still, their loved ones have passed away maybe 2 years now, and they're still fighting to get their assets through probate court. No one wants to have to go through probate court, but a lot of times it's necessary. This allows for greater privacy than a will, and it can be more difficult for creditors to claim assets held in revocable trust in order to satisfy any outstanding debts you may have. I'm gonna go over that too. And when it says it allows you greater privacy, because you don't get that same privacy with a will. So the irrevocable trust is, once you establish an irrevocable trust, you cannot change or modify it. If you transfer real estate or other assets you own to the trust, you can't undo that action. Given that means less flexibility, why establish one in this first place? So again, one main benefit is that it could work as a safeguard. Irrevocable trust would typically be used to create a safe haven for the placement of assets. Like these trusts may protect assets from claims of creditors, beneficiaries, or even Medicaid. Because a lot of times, again, when people get older, they may have to go into a nursing home or assisted living, but they don't want to lose their assets because of it. They may have to go there because maybe they hurt themselves, or they live alone, whatever the case may be. They don't want to lose their assets that they've had all their life. But when you apply for government subsidies and you go into those assisted living and nursing homes, they want you to have nothing. So these type of trusts are good to help them still, it helps them minimize their tax liability, and also helps them protect their assets so they can leave someone. Just imagine, telling someone they worked all their life, they retire, now they're getting up there now, and they're suffering some health ailments, and they have to go somewhere where someone could watch them repeatedly, or monitor their health. But they're saying, yeah, we know that you earned all these things all your life, and you retired and you earned this, but you got to give it all up. You got to give it all up if you want to come in this nursing home, or you want some government assistance from us. So these type of trusts protect your parents and your grandparents from these government agencies making them give up everything that they work for just to be able to get help. So they have this this one I didn't go over, which is a marital trust. A marital trust can be established by one spouse for the benefit of the other. When the first spouse passes away, assets in the trust, along with any income the assets generate, are passed on to the surviving spouse. A marital trust would allow the surviving spouse to avoid paying estate taxes on those assets during their lifetime. The surviving spouse heirs, however, would be responsible for paying estate taxes on any remaining trust assets that eventually go to them. So now the wife or the husband won't be liable for the taxes, but if that spouse, the next surviving spouse, passes away, the children will. But this is something, if you want to protect your spouse, and if you leave, that's why insurance is very important. But if you want to protect your spouse, you guys have a home, assets, and you want to protect them, you would ask your banker or your trust agency about this marital trust. And then this bypass trust. I'm sorry. Yeah. The bypass trust, married couples may also establish a bypass or credit shelter trust, also known as a B trust, to reduce the estate tax impact for their heirs. This type of irrevocable trust transfers assets directly from one spouse to another at the time of the first spouse's death. The surviving spouse, however, doesn't hold the assets directly. The trustee manages them instead, which allows those assets to avoid going into the spouse's estate. When the surviving spouse dies, any remaining assets go to their beneficiaries free of the estate tax. I'm telling y'all, it's so many loopholes that we don't know about. And this is how a lot of people, they keep their generational wealth, and they look out for their family, even in death. This is how you look out for your family. I always tell people when I'm trying to get people to get life insurance, and they're like, I don't need life insurance. You're right, you don't, because it's not for you, it's for your family. This is how you protect your family after you leave them behind. You see how they do this, how they transfer it, and then they could just move it to the kids, so the kids have it, and it's free of estate tax. No one pays the estate tax. So where there's a will, there's a way. I went over the charitable tax. Now they have this generation skipping trust. This is interesting. If you'd rather transfer assets to your grandchildren than your children, you can choose a generation skipping trust. This type of trust lets you pass assets to your grandchildren, allowing children to avoid paying estate taxes on those assets in the process. At the same time, you still have the option to allow your children access to any income that the assets generate. This stuff is informative, people. I'm not versed with the generation skipping trust, but most of us don't have a financial advisor or don't think about these things, because a lot of people think about this stuff like this is just a whole nother bill. I can't think about that. So, but imagine, by knowing all of this stuff, how you could be saving and generating generational wealth for your heirs and grandchildren. So they have this grantor retained annuity trust. A grant is extended to last for only a specific amount of time. It could be a common way for people to minimize taxes on financial gifts to specific beneficiaries. With this trust, you can contribute the assets that you're looking to provide as a gift, and you will then receive an annuity payment on a regular basis based on the original value of the assets. When the term ends, and the remaining funds will transfer to the beneficiaries without any gift tax obligation. So it's like you have this type of, which is self-explanatory, this type of trust, which will pay annually into the remaining funds. So, and then the remaining funds will be transferred. Now, the life insurance trust, this is one that I tell people a lot of time to look into, because most of the time, people with young children, if they don't have family that they trust and they're not married to the spouse, they always put minor children. They're putting 5-year-old children as beneficiaries. That makes no sense. If you pass away today, that 5-year-old cannot receive that money. So these are the times when you want to look into the life insurance trust. So a life insurance trust is a revocable trust that you can designate specifically to hold life insurance proceeds. You designate the trust as a beneficiary of your life insurance policy. When you die, the policy proceeds go into the trust. The trustee then manages the proceeds on behalf of your beneficiaries. The advantage of the irrevocable life insurance trust is that it allows you to avoid estate taxes on the life insurance payouts. Not only that, it protects that child. So it doesn't matter if there's a guardian or whoever takes guardianship of that child. It doesn't matter if they know that child has money coming. That trustee, they manage those proceeds on behalf of the beneficiary and no one else, and it will get paid out however it's set up to pay out. So always look into life insurance trust when you're putting young children on your life insurance, even if they are adults, because a lot of people say, well, when they turn this age, can I just make them the beneficiary? Sure, you can make your adult children the beneficiary, but this trust, and it's letting you know, and it shows you how to avoid estate taxes on the life insurance payouts. So we went over the special needs, and this one here, the Spendthrift Trust, the Spendthrift Trust may give you peace of mind if you're concerned about your heirs basically blowing away their inheritance. This type of trust allows you to specify when and how principal trust assets can be accessed. Like I said, you can set up and you can say, if I die before my child is 21, I don't want them to get, I want them, pay them out, 10% of their inheritance at age 25. So basically the Spendthrift Trust, that's how you can set that up if you don't want them to blow through their money. Like I said, my son at age 16 and a half, when his dad passed, received 6-figure inheritance. So, and there was nothing in place like this. Nothing in place to pay him out the money during certain periods of time. So I had to step in early. So there's a Totten Trust here, and I went over the testamentary trust, but the Totten Trust, also known as a payable on death account, lets you put money into a bank account or other security. When you die, the money that you've set aside is passed on to the named beneficiary on the account. So that's pretty, simple. Like if you're putting money, you constantly putting money into a savings account. That right there, as soon as you pass away, instead of that going to probate also, I do notice that a lot of people don't put beneficiaries on their checking accounts. Put beneficiaries on your checking account, because if you pass away unexpectedly, that bank's going to hold your loved one's money. And then you got to go through probate, get all types of paperwork just for them to release those funds. You don't want to have to go through that. I always tell people, try to plan ahead. You definitely wouldn't want your family going through that, because your family can't even grieve because they're running around like a chicken with no head trying to take care of something that should have been taken care of when you were alive. So I just wanted to go over those. And okay. Okay. So let's go over this here because I'm just basically trying to cover some questions that people may have. You guys not gonna have those questions right here. Let me get this dude off of here because he wants to be known. He wants you to talk to him. Okay. So probate, because a lot of people have a lot of questions about probate, and you may not know how that works. So probate is a court proceeding. As a court proceeding, what goes through probate is generally a matter of public records. So, meaning the descendants' personal financial matters can be seen by anyone who acts. So it says in Massachusetts, a probate court proceeding cannot be closed until at least 1 year after the date of death have passed. So, however, most probates typically last about a year and a half. I told you guys, up to 2 years. Because probate is a court proceeding. Most families need the assistance of at least one attorney, and in some cases, each family member may need his or her own separate attorney. That's when there's several people listed, or separate heirs, remaining. So it says, and consequently, probate can end up being expensive, with the cost associated with probate totaling to be around 5% of the estate size. So, no one, I'm telling you, anything that you can do to avoid putting your family through this probate process. The descendants' assets and property, which are owned individually, are identified, evaluated, and appraised. Remaining debts and estate tax are paid, and what remains is distributed according to the descendants' will, if a will was left, or according to Massachusetts. This is just talking about Massachusetts, but yeah. And guess what? A lot of times when it's tied up in probate court, oh, anybody that you owe, they can come in there. You owe debt, they can come in there and just be picking that money away while you still going through probate. Yeah. Let's see here. I'm not gonna really go over that. Okay. Yeah, I definitely wanted to show you guys there's your bank account beneficiary rules, since I just mentioned that to you. So give me a moment. Okay. So let's go over this because a lot of people don't even know that when they send you all that paperwork, when you first get your bank account, your debit card, there's a sheet on there that allows you to add a beneficiary to your checking account. So it says creating your estate plan may seem like an overwhelming job filled with complicated paperwork. So you've been putting off the process until you have more time. So let's go down here. Who can be an account beneficiary? You're in charge when it comes to naming an account beneficiary. It can be anyone you choose, from the best high school friend, basically, it can be anyone. So you'll probably need to discuss your choice with your intended beneficiary. Charitable groups and nonprofit organizations can serve as bank account beneficiaries. You will need to be certain the group you select is recognized by the Internal Revenue as a charitable organization. Corporations, partnerships, and limited liability companies cannot be your designated beneficiary. I see people, they try to do that, and if they don't come up, basically you can't name them as a beneficiary. So they have to be recognized by the Internal Revenue. These people be having these, janky organizations, and they're like, yeah, the such and such, and you can't pull them up, so they can't be added. So, um, it says, what rights does an account beneficiary have? While you are alive, your accounts are your personal property. You can spend your money, close your account, or change your beneficiaries. Your account will operate it just as it did prior to designating a beneficiary. A beneficiary has no rights to your property until after you pass, just like with a life insurance policy. The only difference you may notice is your account being referred to as an Entrust for or ITF account. But nothing changes, so you don't have to worry like they're not going to have no access to your money just because you're making them a beneficiary. A lot of people, especially older people that I talk to, they be so scary and paranoid. They don't even like to tell people they even have a policy or have things like this in place. But you want to have one person that you can trust. You put all your paperwork all in there and just make sure your family know to go to that place, or that trusted person to go to that place to get that information, because that's the worst thing. When your family don't know if you have insurance, if you do have insurance, don't know with who, where to go, if there's a will, and they're running around nuts. A person can't even grieve when they're going through that. I see it all the time. But you don't have to worry. A beneficiary has no rights to your account until after death. But it's definitely good practice to add them to your account now. Plenty of family members that thought their family had life insurance to find out they didn't have life insurance, but they're like, well, I think they at least have enough money in their account to pay for cremation. You can't even get that money if you weren't listed as a beneficiary. You have no access to that without going into probate court. And you seen what the article said. Probate court lasts a year and a half, up to 2 years. So it says why to select a bank account beneficiary. A POD account is a popular method of avoiding probate and quickly transferring property. After you die, all your assets that are not in a trust or otherwise designed to pass outside of probate will be distributed under the court's supervision. You don't want that. The legal process of probate can take months or even years to complete. During this time, your loved ones have no access to the property you intended for them. When you name an account, does not become part of the estate after your death. It is transferred to the beneficiary and becomes their personal property. Yeah, I'm telling you. So even if you don't tell the person right away, put it somewhere where your paperwork is with a note. Because like I said, I speak to a lot of people. They have the policies, they have beneficiaries, but they are very paranoid about sharing with them that they have these policies. So I don't know. But if you don't have these things in place, wills or trust in place for your family, that's what happens. Your family is going to go through probate court. I mean, being ahead of this, again, a lot of people probably don't see it, but it is definitely going to create generational wealth. Being ahead of this, I see so many family that just give up because they're tired. They spend money going through probate court. They're tired of fighting for something that it's like at this point it's not even worth it because I'm spending more money in the courts fighting to get your assets because you didn't put things in place. That's why it's not about, a lot of people don't want to talk about death and life insurance because to them, it's like it's the inevitable. I don't want to talk about it, but you have to. It's not fair to leave your family destitute. It's not fair to leave your family in debt, because that's what happens a lot of times. You can have the assets, but your family can't touch it because now it went to this state, it's tied up in probate, and now your family's trying to or having to take loans out to pay for your final wishes. Now your family is in debt. You were trying to do a good thing and leave something to them. They in debt now. Put beneficiaries on your checking account, people. You can also do it on your credit cards as well, but put them on your checking accounts for sure. And do not. Oh, another thing. Some people, I speak to people that want to make their pets their beneficiaries. No, you can't. That's insane, because that means that you would have paid for insurance and you pass away and you're adding a cat on your policy, and the insurance company, who are they supposed to pay it to? So now they have to reach out to your next of kin, and guess what happens to your next of kin? Now your next of kin is tied up in probate court to get a policy that you left in your cat name. Do not leave. Do not make minor children beneficiaries. They cannot collect the benefit if you pass away. A trust, a trust, a trust. And I told you the difference between a will. A will is going to go into effect only after you die. And a will is just a document that determines how your assets will be divided and who gets what. The trust has a trustee that is in control, and they administer those funds. They're the ones that's going to be in control of disbursement of those funds. They're also going to be protecting those assets and funds from creditors and from legal disputes. So when you think about, do you need a will or trust, those are the two differences. So I can't really cover a lot of this in a video, because it's so much to trust, so much to understand. But I do hope that I broke it down in layman's terms. At least if you were thinking about getting a trust fund, putting a trust fund for your kids or special needs, I think that that's wonderful. Special needs, because once you're getting government subsidies, they don't want you to have anything. You have to let everything go. And if a parent wants to leave their child inheritance, they shouldn't have to not leave their child inheritance just because their child is on a government program. So I think that's crazy. But yes, people, I'm so sorry I wasn't able to give as much information as I wanted to give on here. I can possibly do a part 2. But again, I do hope that it gave enough information, enough tools, so you can go to your financial advisor and you can go and start looking into setting up wills and trust for your children, especially the trust. Again, I can't stress that enough. If your child's underage, whoever that guardian is of that child, they have the right to the child's assets because the child is a minor. Set up the trust for the child so you can give the child, a foot up, that money. I don't care how much you trust the person. If they need that money, whether they're going to use it to take care of your child or not, if something happens to you, once that money's gone, it's gone. Set trust for your children. So I hope this was another informative video for you guys. And this is Naturally Tora of Tora Talks. I will be dropping another video probably Tuesday. I'll probably do 2 or 3 next week. So I hope you guys did enjoy this. And I appreciate you guys for coming and listening. I hope you guys have a great great weekend because I am recording this on Saturday. So I hope you have a great weekend. Again, stay blessed. Remember to like, share, subscribe. This is Naturally Torah of Torah Talks. Thank you and goodbye.